Welcome back, Chalk and Gavel listeners. Just a few quick announcements before we get to today's show. First of all, we would love it if you would go onto your favorite podcast platform and rate and review Chalk and Gavel. It will really help us expand our reach.
Also, please consider supporting us on our Patreon page. Just $2 a month will really help us continue the content that you know and love. We're also working on some subscriber-only bonus content that we're really excited about. So some current events and some other things in the works. So if you go to patreon.com/chalkandgavel, you can support us there.
For those of you professors of educational leadership working on your fall courses, please know that Chalk and Gavel now has a teaching guide. You can go to chalkandgavel.com and check it out there. We've got a lot of information. We've organized our episodes and the different topics that we've covered in our episodes. It's a great way to include Chalk and Gavel as a classroom resource.
Or for professional development. If you've got something coming up and you want to expose your staff to certain areas of law, hey, consider a podcast.
There you go. All right. Well, let's get into today's show.
What's the difference between creative discipline and excessive punishment? How does a 5-minute punishment set off 6 years of litigation?
Wow.
What does the law say about fastening students to trees?
I think that it would be frowned upon, right?
Yes, actually it is.
But that's exactly what happened, believe it or not, in today's case, Doe versus the Hawaii Department of Education. So this is the story about how a vice principal got himself into a sticky situation by taping his student's head to a tree. Wait, there's more.
Oh no, it's going to be one of those.
Yeah, we got pretty attached to this case after we read it. We will not be masking any facts here. This vice principal's bark was actually just as bad as his bite.
All right. How many more you got?
I'm rooting for the students in this case. I really hope that nobody leaves before we finish this episode. Okay, I'm done.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
Okay, Chris, you got a bell ringer today?
I do, and this is a fun one for a lot of reasons, but also because of a lot of the things we've been talking about recently. So this is a settlement of a lawsuit that the Freedom from Religion Foundation brought against the Memphis Shelby County Schools over what they called serious First Amendment violations. And this all came about because the school district here was giving the Satanic Temple the runaround when the Satanic Temple wanted to start an after-school Satan club.
Oh, fun.
Yeah, that was my first reaction too. So the Satanic Temple wanted to start an after-school Satan club at the school district, specifically at Chimney Rock Elementary School, after a few other religious organizations had started their own after-school programs.
Oh,
yeah.
There's the kicker.
Right, and we've seen the after-school Satan club or the Satanic Temple kind of do this around the country where these organizations will start after school programs like the Good News Club or the Christian Good News Club. And then the Satanic Temple will come in and say like, okay, well, you allowed that religious group to start an after school activity.
Right.
We would like to start one too, because we are also a religious group and you cannot discriminate against us based on our religion. And so what apparently happened here is they came to Chimney Rock Elementary School, said, hey, we want to start this after school Satan club. And the school administrators and folks didn't like that. I think that puts it pretty lightly. And I don't have all the facts, but it sounds like the school administrators and some local community leaders and clergy members put on a press conference kind of like denouncing the Satanic Temple and the After School Satan Club. The Freedom from Religion Foundation said that they gave the After School Satan Club the runaround by like charging them extra fees and doing a bunch of other stuff that they didn't do to other folks. And so ultimately what happened is they settled the lawsuit that the Freedom from Religion Foundation filed against the school for the grand total of $1 in nominal damages.
Wow.
So they're going to pay the Satanic Temple $1 to settle the claims, and they're also going to pay Freedom from Religion $15,000 in attorney's fees and some other costs. I just thought that was a really interesting use of some of this religious stuff that we've been talking about, where you know, a lot of what we've been talking about is coming from the perspective of efforts to inject Christianity into public education.
Yes.
And here we have the Satanic Temple, which is, I don't know a lot about the Satanic Temple, but they, you know, according to their website, they are their mission is to encourage benevolence and empathy, reject tyrannical authority, advocate practical common sense, oppose injustice, and undertake noble pursuits. So, you know, you hear Satanic Temple and you immediately probably go to a slightly darker place than that.
Yeah.
Right. But it's interesting to see this religious organization using religious jurisprudence to advance secular aims.
Mm-hmm. Mm-hmm. That's interesting.
Yeah.
That's fascinating stuff. Thank you for that one, Chris.
Yeah. We'll keep an eye on how these arguments continue to be evolved and used by lots of people in interesting and perhaps unintended ways.
Yeah, exactly. Exactly. Wow. Very cool. All right. Do you want to get into, you want to go to Hawaii for today's episode?
Do I ever?
In our minds.
Oh.
Yeah, that's about it. Yeah.
Oh.
Can't actually go to Hawaii. The show does not have the budget for that.
We don't have enough Patreon subscribers for that quite yet.
No, not yet. We wanted to go see the actual tree where this kid's head was taped.
Gosh.
Okay, well, let's get into today's episode then. Doe versus the Hawaii Department of Education. We're going back to 1998 for this one. All right. This takes place at Pukalani. I'm guessing that's what it is. Pukalani.
I like it.
Pukalani, Pukalani Elementary School in Hawaii. This involves a second grade boy, John Doe. All right. So we're probably talking around 8 years old here. We know, I'm pretty sure John Doe is not his real name. If you have not figured this out already, that's something that they do in the law here, right?
John and Jane
for
Doe.
minors. Yeah, for minors. Okay. So this takes place in February of 1998. John Doe likely had a little bit of a history with administrative run-ins. The case kind of implies that the kid had probably been to the principal's office before.
Once or twice, maybe.
Yeah. Now, again, like have no idea for what or, you know, how severe the infractions might have been or whatever. But keep in mind, you know, John Doe's also like 8. So something happened in early February. He was referred to the principal's office during an after-school program for, quote, acting up, unquote. We don't know anything other than that, but it sounds like, you know, this probably wasn't his first rodeo.
You know, I'm sure when you were a school administrator, like there are those students that you get on a first name basis with because you see them occasionally.
Yes, absolutely. Not sure if Doe was one of those students that everybody sort of knew, but
right, one of your frequent flyers.
Yeah, not sure. Anyway, what happened was February 19th, 1998, Doe gets sent to the principal's office again for fighting with 2 other boys. Okay. We don't know what is meant by fighting. We don't know if like punches were thrown or if they were just wrestling or, you know, we have no idea.
Verbal altercation.
Yeah. So they were just sent to the principal's office for fighting. There were a couple of students who who were already there for something else at the time. So all in all, there are 5 boys that show up at the principal's office for detention.
It's a busy day.
It's a busy day. So the vice principal decides to punish the boys by taking them outside and having them stand with their noses to the wall at the back of the cafeteria while wearing a sign that says, "On detention." They're wearing a dunce cap, essentially.
Right. Yeah. Just wear the stocks, right? Like, let's just lock them into the stocks.
Yeah.
Okay. So
we're off to a good start.
Yeah. Yeah. Right. Like, I think we know where this is going. Obviously, we know where this is going, but like, this is not the best start for this vice principal.
No, we're off to the races now. So the boys are standing there, and after a few minutes, 2 of the boys, they get excused for good behavior. Great. Well done. Nice job, boys.
Yeah. Take off the dunce cap.
Yeah. So then there were 3. So there's 3 students left. And according to the vice principal, those 3 students were horsing around. All right. So he decides to spread them out, and they have to continue standing against the wall with their noses against the wall at the cafeteria. Right.
Okay. Which if they're still horsing around while being on like public display for being on detention, my guess is this punishment is ineffective. Right? Like, maybe at this point we should start rethinking things.
Yeah, but he didn't.
No.
So another student, good behavior, and he's off now. So now it's just John Doe and 1 other kid. And throughout this whole thing, the vice principal keeps telling the boys they need to stand face forward against the wall, or he will, quote, tape their heads to a tree if they continue to misbehave. So,
which is just one of those things you say to kids, like, don't make me come back there.
I would say something similar to that has probably been uttered by a handful of teachers and vice principals and principals over the years, sort of more in a joking kind of way.
Right. Totally tongue in cheek.
If you guys don't sit down, I'm going to tape you to your seat. Ha, ha, ha. Right?
Yeah. Yeah. Teacher humor.
So little did they know.
Yeah. This takes a turn.
So the boys continue to horse around because this was a very effective punishment. The vice principal left for a minute to go check on things in the cafeteria. And when he comes back, both boys are now climbing a tree because they're 8 years old and they're outside. And
right.
They were left
and you
unsupervised.
left them unsupervised with their heads face first against a wall. What did you think was going to happen?
Yeah. So he comes back out and both boys are climbing this tree and they see him come back and they're like, oh no. And they jump down and they rush back to the wall. Okay. Yeah. So all of this sounds totally in line with 8-year-old boys.
For sure. Right.
With most of them, not all of them, but this is not a major shock.
Yeah, none of this
going on here
out of the ordinary, or let's say age inappropriate behavior.
Yeah. So what is age inappropriate behavior is this vice principal deciding at this point, you know what, I'm going to take this other student who's not involved here and tell them to go to my office and get me some tape, get me some masking tape. So this student runs back to the vice principal's office, grabs a roll of masking tape that's apparently about 1 inch wide. So it sounds like a very standard.
Yeah. Do you think it was labeled like for disruptive students? Yeah. Head taping tape.
Yeah. Use only on heads and trees.
Yeah. Oh, it's like the sign for detention.
So he takes the tape and this is the funny part. Well, I was
going to say, we're making light of all of this, but like, this is a very tragic situation. Yeah.
Yeah. This is ridiculous. And honestly, like if an adult, I'll get serious for a second. Like an adult should never tape an 8-year-old's head to a tree. I mean,
or tape an 8-year-old to anything.
No, it doesn't. The tree is not important here.
Right.
But,
yeah.
But like, man, what is that?
What was going through that VP's head, right?
Terrible.
Yeah.
And what was going through the poor kid's head? Mm-hmm. We know what was going around the kid's head. I can't stop. This is ridiculous.
Gosh. Yeah.
Okay.
Oh, well, yeah. Cause like, it could have been a big joke, right? Like, but you took the joke too far. Like, assuming best intentions, right? Like, you get the masking tape and you're like, ha, 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 I've got the masking tape now.
And then it should stop there and you should figure something else out.
Right. Yeah. Cause obviously, using humor to diffuse the situation isn't working. Come up with something else.
But instead, the vice principal, he doesn't do the taping himself. he gets a student, some other student, to do the taping for him. So he instructs this other student to go and tape the boy's head to a tree.
Plausible deniability?
I don't know. I didn't do it. Some people. So the masking tape was wrapped around each of the boys' heads and the limbs of the tree, I believe just once. It wasn't like wrapped multiple times. It was just wrapped around once.
Just a reasonable amount of tape.
Yeah, right. While the vice principal supervised from about 5 feet away. I guess he was just assessing the quality of the work or something. We have no idea whether the students were facing the tree like they were facing the wall before, or if they were facing outwards. It really doesn't matter.
It does not matter.
But we don't know.
I mean, it does, but like it also like
I only
in the grand scheme of things.
Yeah, no, I only mention it so that as you are visualizing what's going on here, we don't know if they were facing the tree or facing out. So apparently they stayed taped to that tree for at least 5 minutes. 5 minutes can be a long time taped to anything.
Yeah.
Right?
Yeah.
Like that 5 minutes is a long time to be taped to something.
I don't think I've ever been taped to anything for 5 minutes.
I don't know if I've been taped to anything for 1 minute. But regardless, it gets even more ridiculous because you know what put an end to all of this? Because it was not the vice principal's, spiritual
Internal
awakening.
Yeah. Better spirit on his shoulder.
The better spirit on the shoulder or whatever, wasn't there going, you know what? This is probably not a good idea. It was a 5th grade girl who came by and was like, Mr. So-and-so, I really don't think this is a good idea.
Good. Okay. Well, hey, somebody acknowledged it, right?
Yes. And so after that 5th grade girl made that comment to the vice principal had that girl do the tape removal.
So he didn't tape him or untape him?
Or untape him. No. And then he apologized to the boys by saying, I just had to do that, which
he
doesn't
did warn them, right? Like, if you keep horsing around, I'm going to tape your head to the tree.
Yeah. Well, I'm a man of my word.
Hey, consistency is very important for discipline. Maybe that's the lesson here is like, hey, don't say it unless you're willing to follow through with it.
Well, I don't. I mean, that's important, but it also depends on what you're threatening them with.
Well, yeah, don't threaten them with something
like this. Oh, boy. So that's what happened, folks. That's fun. It's not like this is ridiculous.
It is ridiculous, and it gets more ridiculous.
On the gavel side of this?
On the gavel side of this, yes.
All right. Well, let's hear a little bit about that.
So apparently not everyone was as amused by this as we are.
You know what? And I just will say, it's 26 years after the fact. If I was there at the time, I would not have been amused by this. Like, I just need to put that out there.
Oh, no,
like,
absolutely not.
What happened, Chris?
Yeah. So obviously, I think Doe and his mother, Jane Doe, also probably not her real name, were pretty upset by this. And so in January of 2000, they filed a lawsuit against the vice principal, against the principal, against the district superintendent, against the state superintendent, for a whole bunch of claims. So we've got some constitutional claims, violations of Fourth Amendment, prohibitions on unreasonable searches and seizures, substantive due process. We've got some negligence claims, false imprisonment, assault and battery, a bunch of other torts, and a couple other state law claims. So this is like one of those spaghetti complaints where they just throw everything at the board against as many people as they can and see what sticks, right?
Yeah.
Spoiler alert, a lot of it's not going to stick.
Okay.
But a few things are. So in September of 2001, the vice principal files a motion for judgment on the pleadings and for summary judgment based on, it's one of our favorite things to talk about.
Qualified immunity?
Qualified immunity.
Are you kidding me right now?
Nope.
Was it the part of qualified immunity that's like, the law doesn't say I can't do this? There's nothing in there that, there's nothing in there about taping a kid's head to a tree, so I didn't know that it was not appropriate?
That is 100% his argument.
Oh my God, seriously. Come on, people.
So qualified immunity.
You know what? I can't blame him for that.
Because
he could have had a lawyer. Right.
It's totally a lawyer's argument, right? So qualified immunity protects public officials from legal liability so that they can basically have discretion to do their jobs. So to be entitled to qualified immunity, a public official can't violate someone's clearly established constitutional rights of which a reasonable person would have known. And so, Jamie, you kind of alluded to the vice principal's argument here, which is there's never been a case that says that taping a kid's head to a tree is unconstitutional. Therefore, I could not have known that what I was doing was unconstitutional.
So please tell me that was a piece of the spaghetti that didn't stick.
That did not, that didn't catch on with the court.
Okay.
Right?
Excellent.
Yeah. So the trial court ends up denying that part of the vice principal's motion. So they reject the qualified immunity argument, and they basically say, no, you don't get qualified immunity for your constitutional claims, but we are going to dismiss some other claims that weren't necessarily appropriate that are unrelated to those constitutional claims. So the vice principal doesn't like that outcome, right? Because he would rather have qualified immunity than not. So he appeals that to the Ninth Circuit. And at about the same time, after a couple of pieces of their complaint got dismissed, Doe decides that they want to add some more stuff in there because they forgot some stuff in the first round. So
Really?
they actually file, yeah, I know, it's kind of hard to believe. They file an amended complaint and they add in some special education claims and some disability discrimination claims because it turns out that Doe had been diagnosed with ADHD. Yeah.
Okay. There you go.
So fast forward to June of 2003. And so the vice
So
principal,
we're 5 years later at this point.
we're already
Yeah.
5 years later.
Yeah.
And at this point, we're at the appellate court. So this is the Ninth Circuit Court of Appeals. We're in federal court because we're dealing with federal constitutional claims. And the Ninth Circuit has to decide whether or not to affirm the trial court's denial of qualified immunity. So the Ninth Circuit basically has to determine, should this vice principal be getting qualified immunity? And there's a couple issues that the appellate court has to deal with. They have to deal with this question of like, what's the constitutional standard we should be applying here? And then, was there a constitutional violation? And if there was the right clearly established or not to give the principal kind of notice that what he was doing was a reasonable person would have found that to be unconstitutional.
Okay.
Or would have known it was unconstitutional. So the legal standard here, there's a couple different buckets we could put this in. So it could either go into the Fourth Amendment bucket against unreasonable searches and seizures, or, and we've talked about both of these on this show, or it could go into the 14th Amendment substantive due process bucket of conscious shocking behavior.
Okay.
Right? Because substantive due process keeps you or protects you from arbitrary or egregious.
Excessive. Yeah. Yeah.
Exactly. Yeah. And so the court here is like, okay, well, which bucket do we put this thing in? Honestly, it kind of doesn't matter because this is, if anything is egregious and conscious shocking, it's taping a kid's head to a tree, right?
Yeah, seriously.
But they look at this and they're like, okay, well, the substantive due process standard, that's really broad. And the Fourth Amendment standard is really specific. And this was clearly a seizure because you taped his head to a tree and kept him from moving. So let's do this under the Fourth Amendment because it's more specific.
Okay.
And so they say that, when we're looking at excessive force claims involving searches and seizures, we're going to use the Fourth Amendment. So now with that, though, the VP argues that the Fourth Amendment can't apply to him because he wasn't acting as a law enforcement official in an investigatory capacity.
What?
Yeah, and that doesn't fly. That flies about as well as the I didn't know argument. But yeah, the court very quickly dismisses that and says, we've found the Fourth Amendment applicable to schools in relation to searches and seizures. It also applies to administrative seizures, which is kind of what you were doing, but you were also engaging in discipline. So like, good try, but we're going to keep going.
I don't even know if it was a good try. It was just a try.
Yeah, I guess let's call it a good faith argument.
Okay.
Yeah, it passed the smell test, but it didn't get much further than that.
Yeah. Okay.
So the next thing the court has to look at is was this actually a Fourth Amendment violation? So for it to be a seizure covered by the Fourth Amendment, a seizure occurs when there's a restraint on liberty to a degree that a reasonable person would not feel free to leave.
Yeah.
In basic terms, right?
You can't really leave if your head is taped to a tree.
That would be a restraint on liberty, freedom of movement, right? And a reasonable person would not feel free to leave when their head's taped against a tree.
Yes.
Yeah.
Yes.
So taping someone's head to a tree definitely qualifies as a seizure.
Okay.
But not all seizures are unconstitutional.
Excessive. Yeah.
Only unreasonable searches and seizures.
Yeah.
And so here, to determine the reasonableness, we look to whether or not the search and seizure is reasonably related to its purpose and is not excessive in light of the age and sex of the student and the nature of the infraction. If that sounds
pretty
familiar,
much fails on a few things there, huh?
on many of them. But yeah, this is basically the TLO standard, right? From we did this in episode 15 with searches and cigarettes.
Mm-hmm.
But yeah, clearly this was not reasonable. There was nothing about his behavior that indicated that it was necessary to tape his head to a tree.
Right. He's also 8 years old.
Age and maturity, right?
Yep.
Like 8 years old, didn't know what he was doing. And it's clearly excessive because you had to get a 5th grader to tell you, hey, that's not right. Right. So we've got a constitutional violation here, right? Like it's pretty...
Surprise.
What's surprising, though, is it took 5 years to get to this point, right? And so with qualified immunity, we kind of joked about this already, but like the right to be free from excessive force at the hands of teachers, that's clearly established, right? Like we've known about that for a very, very long time. The vice principal did argue that, there's not a ruling saying that taping someone's head to a tree is unconstitutional. How was I supposed to know? And the court doesn't necessarily laugh him out of court, but they say, this is a direct quote from the court, there need not be a case dealing with these particular facts to find the vice principal's conduct unreasonable. Indeed, it would be difficult to imagine this situation recurring with any frequency.
Yeah, I think that's a better way to do it than laughing them out of court.
Right.
That's a clear...
It's a clear indication like,
there.
hey, the thing you did was so ridiculous that no one else has done it or will do it.
Yeah.
That doesn't make it okay.
Yeah. Just because nobody's done it before.
Right.
That makes perfect sense. Okay.
Right. So the Ninth Circuit Court of Appeals concludes that this is a Fourth Amendment violation, that the vice principal does not get qualified immunity, and so they remand the case back to the trial court to continue along the process. So this is now December 2003, January of 2004, and everybody's making motions. Doe is making motions for summary judgment. The defendants are making motions for summary judgment, motions for the pleadings, motions to strike. Everybody's motioning everywhere. A lot of that's not really that important for us, but also at this time, in December of 2003, the defendants, the school district and the state, offered to settle the lawsuit for the grand total of $90,250.
Oh.
Yeah.
So they're like, okay, I don't see us winning here, so can we pay you?
Right. Yeah. Well, it's like, part of it is there's some rules of civil procedure where, like, if you offer a good faith settlement offer before you go to trial, then if you end up losing, but you don't lose as bad as the settlement, then they can't get attorney's fees, or there's some strategic things here about making a good faith settlement offer at this stage. But that $90,000 was supposed to cover both Doe's damages, so like the harms that he suffered, as well as Doe's attorney's fees.
Oh, okay.
And as we know from
yep.
As we know from some of these cases, those add up pretty quick, right?
Uh-huh.
But Doe likes their odds. They just, were told that this was essentially a constitutional violation, and so they deny or they don't accept the offer.
Okay.
Maybe they should have, because what happens next in 2004, in February of 2004, almost exactly 6 years after the incident, the trial court issues another decision dismissing a whole bunch of Doe's claims against everybody except for the vice principal who actually taped his head to a tree.
So all of those claims stuck with the vice principal, but not anybody else.
Right. Yeah. There was the adhesive was not strong enough to keep the rest of those claims in this lawsuit.
Okay. Yeah.
That was a bit of a stretch.
I know.
So at this point, the only claims left are the ones against the vice principal, who is responsible for taping the head against the tree. Basically, the other ones got dismissed for a lot of different reasons, but essentially, they weren't the right party. They weren't the right claims. The special education claims got dismissed at this point too, because he hadn't exhausted his administrative remedies and nobody knew that he had ADHD apparently. So it was just, all we've got left are a couple torts and the constitutional claims against the vice principal.
All right.
So in June of 2004, 6.5 years later, this thing goes to a trial in front of a jury, and the jury finds in favor of Doe on his Fourth Amendment claim, and they also award him punitive damages.
Oh, great.
Which is, that feels a little heartwarming, I guess. Maybe that's not the right word, but
he won. He won.
Some justice got done here. And punitive damages, the whole point of punitive damages is not to compensate.
Yeah.
It's to punish, right? It's what you did is so bad. We need to hit you with some more financial incentive not to do it again.
Exactly.
But here's the thing that like maybe adds a little bit of a, what's the opposite of a silver lining? Gray lining?
Add some salt to the wound, huh?
There you go.
Yeah.
So they awarded him the grand total of $1,125 in compensatory damages.
And they just went like absolutely the sky's the limit with the punitive damages?
$2,500.
What? Wait, what?
Yeah. So
the school, wait. The school was going to settle for $90,000, but instead the jury awarded them a grand total of $3,625.
Yes.
Well, that's a little different than 90,000.
Yeah. No, it's one of those moments where it's like, ooh, maybe we should have taken that offer.
Yeah. Wow. And they won.
They won, right? Like, and that's the thing. Like, maybe it's a hollow victory, but I don't I don't have the record in front of me to say like what damages they put forward, right? So like compensatory damages, you have to prove like I was harmed because of your action. So like whether that was psychological harm, trauma, counseling.
Yeah. You're being compensated for what happened to you.
Right.
Yeah.
So like maybe they just didn't put on enough evidence, or the jury didn't believe the evidence they put on. I don't know. But 6.5 years later, that does seem like a pretty trivial amount, especially when they were offered $90,000. Now, the $90,000 that they were offered, that was before the court dismissed a bunch of claims. So like that was for all of the defendants for all of the claims. And the court kind of looks at this and says like, oh, well, that $90,000, like that wasn't just for the things you ultimately won. So we really can't look at that when we're thinking about whether or not you should get attorney's fees.
Yeah,
because
this is ridiculous.
You want to know the wildest part?
What's that?
We're not done because
I thought we're done.
No. In February of 2005, 7 years later, after the verdict, Doe moves to recover his costs and attorney's fees from the defendants as a prevailing party. So he did win, right? Like he won $3,500. But now he wants to get his attorney's fees and recover the costs that it took to bring the case. So he asks for $52,509 in costs. And that includes things like hiring investigators to develop evidence, paying for expert witnesses, filing costs, copies, video conferencing, depositions, lots of things that add up in when you're bringing these sorts of cases.
Okay.
And he also asks for $112,818.20 in attorney's fees.
Okay. So he's basically asking for $165,000.
Right. After winning $3,625 in damages.
Okay.
And the court ultimately awards nearly $100,000 in attorney's fees and $27,000 in costs.
Okay. All right.
So that's great.
So he's a lot closer.
Except that money goes to his attorneys, not to him.
Not to him. Yeah.
Right.
There's the punitive damages.
Well, the punitive damages do go to Doe, but like.
No, I know, but like they don't, like it's $2,500, right? Like it's not.
Right. Yeah. So like ultimately, the biggest chunk of change here is the attorney's fees. And this thing took 7 years to get to that answer. Like it just kind of leaves me very, very dissatisfied, I guess. Right? Like,
yeah. That kid should not have gone through what they went through. That vice principal should
never have done that. Right.
Should not be vice principaling. And it is a little anticlimactic how this kind of turned out. Like you really wanted I wanted to see like some harsh stuff here, even if it was just harsh language,
right?
As opposed to
some chastising, right? Like,
like I want something.
That's one of the things. Like we talk a lot in this show about like what students' rights are and where the law is, but the law is only as good as it's enforced. And I think that is a really important thing to kind of recognize. We're like, we know what the law is. The law says don't tape a kid's head to a tree, but it's going to take 7 years, $170,000 in costs to get to the point where a jury tells you that.
Yeah, no, that is a little.
But like, the state ended up paying that money, right? Like,
yeah.
Still had to go through that process, and that process is hard for everyone. So like, this 5-minute incident leads to this 7-year saga.
Man, well.
But hey, thanks for sticking with us through that episode.
Oh boy. I'm not gonna even attempt to do another one. I got all of them out at the beginning, and I think we've milked this one as much as we can. Let's just go to our homework.
You're gonna leave me hanging like that? See, you got all of yours at the beginning. I've got to.
Yeah, I know.
I got to fit mine in
spread
somewhere.
yours out.
Yeah.
All right, what's our homework?
All right. So your homework, find Chalk and Gavel wherever you get your podcasts. Like, rate, review, subscribe. Find us at chalkandgavel.com. You can find our teaching guide there, as well as a link to our Patreon, patreon.com/chalkandgavel. If you could support us, we would absolutely love it. And we value everything you can do to spread the word and engage with the show. We look forward to continuing the conversation.
All right, everybody. Thanks for listening. We'll see you in a couple of weeks.